Namaskar. Hello and welcome to Bookmark. Today at Bookmark, we are to talk of the most cherished freedoms, that is, freedom of speech and expression, and we are to discuss the reasonable restrictions that operate and control this freedom. Before we move to our discussion, I'll be just sharing two examples in order to highlight the significance of this topic. While we are all active on social media, majority of us must have experienced and must have noticed these two messages, which I now am quoting for you. Example number one is a viral photograph of a police officer who is shown to be in his uniform. His uniform is a bit tarnished and he is shown to be soaked in blood. Blood is shown oozing from his forehead, and below the photograph we get to read the matter, which is thus. किसी गोमाता का रक्षण करते हुए इस पुलिस अफसर को अपने जान से हाथ धोना पड़ता था अगर कुछ लोग इसे नहीं बचाते. कुछ मुस्लिम गुंडों ने इस जाबाज पुलिस अफसर पर हमला बोल दिया था और बड़े ही मुश्किल से ये गाय का गोमाता का रक्षण कर पाया और कुछ लोगों ने इनकी जान बचा ली. अगर आप इस फोटो को एक लाइक करते हैं तो आपका एक लाइक इस अफसर की जानिसारी को एक सैल्यूट बनता है. एग्जाम्पल नंबर 2 is that of a photograph or an image of a masjid. The masjid is shown to be in a dilapidated condition, and below that photograph the matter that we get to read is that कुछ कट्टरपंथी हिंदू गुंडों ने उत्तर प्रदेश के मेरठ जिले में ये मस्जिद गिरा दी है. जब हम हिंदुस्तान एक धर्मनिरपेक्षतावादी राष्ट्र होने की बात करते हैं तो क्या आपको ये देखकर गुस्सा नहीं आता है? This is the second message. Now what is to be noted is that people who are active in sending such messages, in sharing such messages, and at times people even who like such messages are completely ignorant, unaware of the fact that they are becoming a party to an offense under Indian Penal Code, and that is section 153 capital A, which is creating enmity between two religious groups, and for which the punishment prescribed under the law is 3 years of imprisonment. Now, people who are active in forwarding and sharing such messages are completely unaware that as to whether the photograph really is that of a police officer who was involved in such act of saving a cow, or whether the police officer suffered some accident because of which the injury was caused, or he had a fall somewhere because of which the injury was caused. People are completely unaware that the masjid which is shown to be brought down by a group of Kattarpanthi Hindu goons, that is fundamentalist Hindus, is in fact a masjid that collapsed because of a natural calamity of earthquake in Iraq. So unaware of the factual aspects, people keep on recklessly sharing such messages and become a party to an offense under the law, which to their good fortune they are not booked. If booked, then they will have to face the consequences. Now we are coming to the topic of today's discussion, and that is right of free speech and expression. The Constitution of India begins with the preamble. The preamble contains some 85 words. In 85 words, the makers of the Constitution have encapsulated in short as to what are the ideals, what are the aspirations of the people of this country that the Constitution thinks of pursuing, and it also pursues. So in 85 words, it is just a short summary of the Constitution. And the preamble, as we all know, reads, "We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure for all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship. So liberty is further classified, that is freedom is further classified into these five categories, that is liberty of thought, expression, belief, faith, and worship. So the word expression now for the first time in the text of the Constitution finds a place in the preamble. Then we'll have to move to part 3 of the Constitution of India, which is the chapter of fundamental rights. From Article 12 to Article 35 of the Constitution, the chapter of fundamental rights, we get to read that. In the chapter of fundamental rights, just to give some examples, we get to read right to religion, rights of minorities, right to life, right of equality. And in the list of these rights, there comes one article, that is Article 19, which speaks of 6 different freedoms. What are those? Freedom of speech and expression, 1. Freedom of association, 2. Freedom to assemble peaceably without arms, 3. Freedom of movement, 4. Freedom of residence, and 6. Freedom to pursue a business, trade, occupation, and profession of one's own choice. So these are the 6 freedoms that we get to see enlisted under Article 19. Out of these, the first is 19(1) subclause A, that is right of free speech and expression, freedom of speech and expression. The day on which the discussion went on in the Constituent Assembly amongst the makers of the Constitution, Professor K.T. Shah had put a question to Dr. Babasaheb Ambedkar as to why doesn't the Constitution specifically speak of freedom of press, because we all know the contribution and the role that the press, the print media had played in bringing freedom. The sun of freedom dawned on India only because of the contribution of the print media. So this question was put as to why doesn't the Constitution speak of freedom of press in addition to freedom of speech and expression. And the answer given by Dr. Babasaheb Ambedkar was very particular. He said that the term expression is so all-pervasive that it will include all kinds of expressions, let that be a poetic work, let that be a work of literature, or let that be some article or news item published in a newspaper. So this is the glimpse of history of incorporation of the term freedom of speech and expression in the Constitution. Now let us move to the restrictions that operate on this freedom. There are in all 12 restrictions that we are now to discuss. First amongst them, sovereignty and integrity of the country. So any expression that comes to the way of people should not be a threat to the sovereignty and integrity of the country. This restriction, sovereignty and integrity, was not there enlisted in Article 19(2) on the day on which the Constitution was adopted, that is 26th of January 1950. It was later incorporated by way of an amendment. The history to the amendment, there is a prelude to that, and which is that in the year 1960, there was intrusion on a large scale by China in the Purvanchal territory of India. In Punjab, Sardar Tara Singh was a leader who had raised a demand for a separate nation for Sikh community. In South India, the political outfit DMK had also raised a demand of a separate nation comprising of the territory of certain portion of Andhra Pradesh, Kerala, and Madras. So these 3 territories were asked to be further divided and a separate nation was asked to be carved out. So considering the situation then, which was highly inflammable, the then Law Minister, Mr. Ashok Sen, proposed a amendment to the list of restrictions under Article 19.2, and by way of that amendment, sovereignty and integrity was first incorporated as a restriction. We then come to the second restriction, and that is security of the nation. Now, this security of the nation, just to elaborate further, we'll have to talk of an example which had happened in our country during the 26/11 terrorist attack. We all have witnessed how brutally a group of terrorists led by Ajmal Kasab and the group which was accompanying him had killed and murdered innocent people at Mumbai at various locations. One such location was Nariman House. So in Nariman House, many innocent people were held hostage by a group of terrorists. And so as to rescue those innocent people, the armed forces, the commandos, had conducted a security operation, which was the rescue operation at Nariman House. We have witnessed on television channels, in the news channels, that the team of the commandos, who was specially assigned the job to conduct this rescue operation, had landed on the terrace of the Nariman House by the aid of choppers and helicopters. So while the whole operation was in progress, the electronic media in our country, very irresponsibly, what it did was it has shown a live broadcast of the entire event of the rescue operation. As a result, the terrorists who were housed in the Nariman House, holding the innocent people as hostage, could get a clue of every second the movement of the armed forces, the window or the direction from which the armed forces were likely to come in the Nariman House so as to save the innocent people. So they were all prepared and they could retaliate with all the preparedness that they had with the armed forces, and as a result, the armed forces faced great difficulty to conduct the whole rescue operation. Even the Supreme Court of India had severely criticized the irresponsible behavior of the electronic media in showing a live broadcast of the rescue operation. So, any communication, any expression, any message that is coming to the public at large has to be such that it may not cause a threat to the security of the nation. So this is the second restriction. The third restriction is any communication or any expression that is coming in the public should not cause some adverse effect on the friendly relation of our country with a foreign state. In the year 1932, the British government passed a separate law, that is Friendly Relation with Foreign State Act of 1932. The law hardly consists of some 7 to 8 sections, where the procedure is prescribed that in case there is some communication that is made public which will adversely affect the friendly relation of our country with some other foreign country, then the person can be prosecuted under the provisions of that law. So what we need to remember, that the way there are friendly ties between human beings, there are friendly ties between two countries, and so as to maintain those friendly ties, the communications that are made in public are to be maintained in such a way that they don't adversely affect the friendly relation of our country with some other foreign country. The next restriction is the word public order. The word public order was inserted in the year 1951 to the list of restrictions by Pandit Jawaharlal Nehru's government by way of the First Amendment. And there were 3 judgments delivered by the Supreme Court that are found to be the ignition point for incorporation of the word public order. And why I say so? Because it was found by the government that the word public order, since it was not a part of the list of restrictions, the government could not control the newspapers, and such incidences had occurred in Madras, in Delhi, and in Bihar. So there are three judgments delivered by the Supreme Court which are responsible for incorporation of the word public order, and those three judgments are: number one, Romesh Thapar versus State of Madras; number two, it is Brij Bhushan versus State of Delhi; and number three is Shail Bala Devi versus State of Bihar. Then we move further to obscenity, the restriction of decency and morality. So any communication that we come across has to be within the limits of decency and morality. What is decency is not defined anywhere in the Constitution. But in order to understand what is decent, we'll have to just see as to what is the opposite of the word decent. It is obscene. And obscenity is defined under Section 292 of Indian Penal Code. Any person whose message, whose communication, whose expression doesn't fall within the limits prescribed of obscenity in Section 292 of IPC will have to suffer an imprisonment of 2 years, imprisonment up to 2 years. But then obscenity is a highly fluctuating concept. It is a volatile concept. It keeps on changing with times, the way society evolves, the way society progresses gradually. It was considered a taboo some 40 years ago to speak of the rights of the LGBT community, that is the lesbian, gay, transgender, bisexual. But today it is a common thing. It was considered obscene, a certain line of a song some 40 years back, but now it is a common thing. So obscenity might be a fluctuating concept, but then there is a specific section 292 in Indian Penal Code that defines obscenity. Just an interesting trivia for your information, that in Maharashtra, Dr. Karve was a leading social reformer who had contributed a lot in sex education and creating awareness about use of contraceptives for family planning. Dr. Karve used to publish a magazine titled Samaj Swasthya, and he used to author certain articles creating enlightenment in the public at large about the methods for family planning. One such article, because it was authored by Dr. Karve was prosecuted under Section 292, that is the offense of obscenity, and a prosecution before a criminal court was lodged. Dr. Karve ultimately was acquitted by the court, but it was Dr. Babasaheb Ambedkar who had fought the trial on behalf of Dr. Karve, who was an accused in the trial, and Dr. Babasaheb Ambedkar could fetch an acquittal to Dr. Karve, and certainly Dr. Karve was doing a work for the welfare and good of the community at large. Then we move to the further restriction, which is contempt of court. Now, all of our knowledge about courts, of course, those who visit court regularly are quite aware of the reality, but those who haven't visited court, we borrow our knowledge from what we get to see in films. Whatever we get to see in films and teleserials might not be the complete truth, but a certain part of that is true. What I mean to say is that we all get to see that the lawyers, while addressing the judge before the court, address the judge by putting a prefix of my lords. They address the judge by saying your honor. Whenever a witness comes to depose before the court, the witness is administered an oath. And while administering the oath, he is asked to say, Bhagwan kasam sach kahunga, sach ke siva kuch na kahunga. While the proceedings of the court start, whenever the presiding judge arrives in the court hall with his orderly, the orderly commonly utters the words like silence or hoshiar. Now, what are all these? These are all symbols that we need to revere courts because they are a significant wing of the government. Students of political science are usually taught that the government is run by three different pillars: legislature, executive, and judiciary. So, judiciary, being one of the pillars of our democracy, needs to be respected. And to maintain that respect, there is a separate enactment for maintaining the dignity of the courts, and that is Contempt of Court Act. Section 12 of the Contempt of Court Act prescribes a punishment up to 6 months for causing contempt of the court. Contempt is further divided into two different categories. One is civil contempt, another is criminal contempt. What is the distinction in short? If the High Court directs a local municipal authority to cover the potholes in a city within a span of 3 months, and the municipal authority fails to adhere to the timeline given and set by the court, then the commissioner or the head of the municipal authority who will be charged with contempt will be charged with civil contempt. So whenever the court gives certain direction to a authority and the authority or the officer fails to comply that direction, then the contempt which is committed is civil contempt. The other contempt, other kind of contempt is criminal contempt. Now, many of us must have come across these news items that some every 6 months or once in a year we get to see that a accused in a case has thrown pair of his shoes towards the presiding judge while a trial was in progress. So this is an example of criminal contempt. Not only physical attack, but attack by way of utterances, by way of writing certain articles, publishing them, writing certain posts on social media, which might cause some suspicion in the minds of public at large about the functioning of the courts, about the integrity of the court, then that would fall under the category of criminal contempt. So this is contempt of court. Now the next restriction, that is defamation. Those who have followed speeches of Atal Bihari Vajpayee, they may recollect that when for the first time the BJP-led government had come into power in 1996 and it collapsed after an administration of 13 days, Atal Bihari Vajpayee delivered a speech in the parliament. And while he addressed the parliament, he quoted Bhagwan Ram by saying, भगवान राम ने कहा था, नभी तो मरना दसवीं केवलम दूषितो यशा, मुझे मृत्यु से डर नहीं लगता, लगता है तो बस बदनामी से लगता है, लोकापवाद से लगता है. And while saying so, he was trying to tell people how we value our fame, our reputation. So ultimately, apart from one's body, anything that an individual will cherish is his image, his reputation in the society. So, defamation is one of the restrictions, which means that we are all free to communicate with each other. We are all free to publish whatever we wish to. We are all free to author whatever we wish to. But the content of our writings, the content of our utterances should not be such to cause defamation of anybody. Defamation is defined under section 499 of Indian Penal Code. The punishment for defamation is given under section 500 of Indian Penal Code, which is 2 years of imprisonment up to 2 years. Defamation, a person who is aggrieved by the offense of defamation has two remedies, two options available to him to pursue. One is the criminal complaint under 499, 500, and other is that he can invoke the jurisdiction of the court to demand damages by way of filing a civil suit. So a civil proceeding, a person by filing it can demand damages from the civil court, which the court will quantify as per its satisfaction and as per the proof tendered by the person before the court of the defamation caused. The next restriction, which is the last in the list that is specified in Article 19.2, is incitement to offense. So whenever a person is writing, communicating, expressing, is supposed to restrain himself in such a way that his utterances, his words, spoken or written, should not invoke some person to commit some offense. So one is not supposed to fan communal fire. One is supposed to keep the society in its harmony by way of whatever one is expressing. So incitement to offense, if you wish to read further, you need to read the definition of the word abetment, which is a synonym of incitement or instigation, and that definition you will find under section 107 of Indian Penal Code. Any communication, this restriction means that any communication need not incite any person to commit an offense. The next restriction is that of sedition. Now this is the most talked of restriction in recent times, simply because of the example of Kanhaiya Kumar, Akbaruddin Owaisi, Asim Trivedi, against whom the charge of sedition is invoked and the trial is in progress. So far as against the cartoonist Asim Trivedi, initially the charge of sedition was there in the sections that were invoked against him, but at a later stage the charge of sedition is dropped and he is being prosecuted under the provisions of Respect to National Symbols and Emblems Act. So sedition is the most talked about restriction recently. It is talked about for a reason that people believe that the provision is being misused and abused a lot. Whether it is so or that is just a common perception is a matter of discussion that we have separately. The offense of sedition is defined under section 124 capital A of Indian Penal Code. The punishment prescribed is imprisonment up to 3 years for sedition. The section in short says that any person who tries to create disaffection against the policies of government and at the same time invokes people to commit offense would be responsible for the offense of sedition. So the word is that creating only disaffection in the minds of people against the policies of government is not sufficient. The disaffection has to be such that people are to be instigated to commit offense. And so the explanation is also given under section 124 capital A that any fair criticism of the policies of the government will not amount to sedition. Then the next restriction that we are to speak of is hate speech. Now, majority those who are listening to this lecture will agree that almost half of the political leaders who are there in the fore, let that be any particular state or even in the country, some or the other time in their political careers have actively been involved in some act of fanning the communal fire by delivering hate speeches. Hate speech is not separately carved out as an offense like in the word hate speech, but the example which I gave at the outset, that of some messages being made viral that are likely to create communal discord between two sections of society, that is section 153 capital A, is an offense under Indian Penal Code. So a person who is indulging into hate speech can be imprisoned up to 3 years for commission of the offense of hate speech, which consequently causes enmity between two sections of different religions. Then there is chapter 15 of Indian Penal Code, which speaks of section 295, which then states that it is an offense to hurt the religious sentiments of people. Now, what are religious sentiments? We'll have an independent discussion on that, but we need to remember these two sections, 153 capital A and 295 Indian Penal Code. And for 295, the punishment is 2 years of imprisonment. Now let us speak of right to privacy. See, all of us must have experienced this, that while we are in our living room watching some television show, while the television set is on, we have the remote control in our hand, and suddenly some guests arrive into our house when in fact we were not expecting them. And when such guests arrive, we suddenly become very conscious about now how to tackle with the situation, how to deal with them, because we have to be hospitable towards them, and then we'll have to leave our favorite movie or favorite television show halfway. We become conscious for simple reason because we were, prior to the arrival of the guests, enjoying a certain private space. That means we were enjoying our right to privacy. The question is, then, does the Constitution acknowledge this right to privacy? Yes, it certainly acknowledges, though there is no specific reference to right to privacy in any of the provisions in the chapter of fundamental rights, but the Honorable Supreme Court of India, in the landmark judgment of Khadak Singh versus State of Punjab for the first time, said that right to life under Article 21 includes right to privacy. This right to privacy, mark my words, is not something which is available only to celebrities. It is also available to any common man. Right to privacy, just to give you an example, how it is also acknowledged by the press and media. It so happened that we all know the star couple Aishwarya Rai and Abhishek Bachchan. When Aishwarya Rai was pregnant and was to deliver a child, a guideline was issued by the News Broadcasters Association to all the news channels which were a member of the association. And the guideline was that whenever the delivery of Aishwarya Rai occurs and the child is born, a news item will be given, but it will be only one line news, nothing beyond that. So no discussions about the horoscope of the child, whether the child looks and resembles the father or the mother, no such spiced up discussions about the birth of the child. And this, the guideline said, that is being done to respect the privacy of the couple. So right to privacy, in this way, it operates as a restriction on freedom of speech and expression. The next restriction, which is the last in the list, is the immunities and privileges that are conferred on the members of parliament and members of state legislatures. Section Article 105 of the Constitution of India speaks of the privileges and immunities of the members of parliament. Article 194 of the Constitution of India speaks of the privileges of the members of state legislative assemblies. These privileges are then further classified. Well, we can have a detailed discussion on what these privileges are, but these are just a few examples that we are discussing over here to make the subject more comprehensible. So, the privileges are further categorized: 1, individual privileges, and 2, collective privileges. What is an individual privilege? So, if I am a member of parliament or a state legislature, and if I am delivering a speech which is derogatory to someone at a public place, then that someone can certainly file a prosecution under section 499-500, that is the offense of defamation, against me, for which I will be answerable before the court. And if I am not in a position to give a satisfactory reply to the court may find me to be suitable to be imprisoned up to 2 years, which is the punishment prescribed for defamation. But if that very speech in which the derogatory remarks were made against a person is delivered by me on the floor of the parliament or the state legislature, then the constitution protects me by way of an individual privilege that no person who is member of the parliament or the state legislature can be prosecuted for whatever he says or speaks during the course of discussions that are held on the floor of the parliament or the state legislature. So this is one of the individual privilege. There is a collective privilege available to the members also. What is the collective privilege? Another example, it so happened in state of Maharashtra that the Maharashtra government had imposed a ban on the dance bars in Mumbai. The dance bars are such bars where the women, ladies who are employed there do serve liquor to the customers who visit these bars. And they also indulge into artistic performance of their dances. So, such dance bars were banned by the Maharashtra government. The ban was opposed by the Dance Bar Owners Association. Now they said that they have their right to business, trade, occupation and profession, and they had certain points to make before the government of state of Maharashtra. And in order to put forth their demand to the government, they had arranged for a procession and a demonstration in Mumbai. The procession consisted of almost 400 to 500 people. It was led by one of the office bearer of the association, and it was one Mr. Sethi. His name was Sethi. So Mr. Sethi, in the course of the procession, while the procession had a halt somewhere, delivered a very fiery speech during the course of procession. And in that speech, he uttered certain words which were abusive, obnoxious and offensive, and those words were addressed to the wives of the members of the state legislature. So to the women class, particularly the wives of the members of the state legislature, some very abusive and obnoxious remarks were made about. And taking a cognizance of that, a serious cognizance of that, the state legislature summoned Mr. Sethi, called for an explanation from him, and finding the explanation to be not satisfactory, Mr. Sethi was imprisoned for a period of 90 days. So this privilege, which was exercised by the state legislature in Maharashtra, in Mr. Sethi's case, is nothing but an example of collective privilege or collective immunity that the members of the parliament or the state legislatures had. So these were in all almost 12 restrictions on free speech and expression that we have discussed today. Before we conclude, I feel like giving this illustration of the favorite game of our country, that is India, that is cricket. Favorite game of our country, that is cricket. In cricket, we have seen that there is a batsman who has to perform, and while he performs, he has to be cautious about the fielders who are there ready on their toes to get a wicket of the batsman. They may catch the batsman at any place. So whenever he has to score, he has to hit between those two fielders, finding a gap, or otherwise there is all possibility of the batsman getting caught. And we have also witnessed that despite such hindrances, hurdles, and all of those fielders who are placed in their positions, we have such world-class batsmen who have scored so high and who have scored breaking all the records of the highest runs by any batsman. What I'm trying to say is that while any person who is into any communication over the social media platforms or some news items in newspaper, if a person is a journalist, if a person is a simple middle class individual and is just active on social media, any and every person needs to remind himself that the constitution, though guarantees freedom of speech and expression, at the same time it expects you to communicate by maintaining a decent standard of your communication within the limits of the reasonable restrictions who are there placed to mind you, to catch you, and if you hit a wrong and erroneous shot, then you are likely to lose your wicket. So that's all for today in Bookmark: Freedom of Speech and Expression and the Reasonable Restrictions. We'll meet again for some other topic in relation to law. Thank you.